Hello, my name is Ariana Mavromichalou, Senior Legal Advisor at Consulco, and I will be telling you about how the UK legal framework ensures the swift repossession of loan security properties if and when necessary. Consulco Capital has established the London Credit Fund, licensed and regulated by the Cyprus Securities and Exchange Commission. The London Credit Fund provides the opportunity to well-informed and professional investors to profit from the benefits of the 6 billion London short-term lending market. More specifically, the fund and its subsidiaries will invest in short and medium-term London property secured loans which are underwritten, structured and pre-funded by London Credit Limited. The target return for its Euro investors exceeds 4% per annum and it's payable quarterly. The London Credit Fund's underlying loans are secured against UK real estate, one of the most prime investment assets in the world that provides solid security and comfort to all funds investors. Despite the fact that London Credit Limited has achieved an impeccable track record of more than £100 million worth of loans for a continuous period of 10 years, there is always a possibility the borrower fails to repay a debt, including interest or principal on a loan, or he breaches any other terms of the facility agreement. For these reasons, secured loan agreements describe in detailed terms the events of default which must occur before a lender can enforce any of the securities in place to cover the obligations of the borrower, as well as the procedures of enforcing those securities. The secured loans, breaching or otherwise, are advanced by London Credit Limited as a lender, and these loans will form the basis of the London Credit Fund investment. The loans are always secured by legal charges on real property, residential or commercial, and the loan-to-value does not exceed 75%. The security properties are valued by a risk professional valuer from a reputable firm who is covered by indemnity insurance to cover losses borne by the lender due to the valuer's negligence. The legal completion of the legal charges and legal due diligence of the borrower and property is carried out by reputable solicitors who are also covered by indemnity insurance. The residential security properties are all investment properties which are not occupied by the borrower or family members, and as such, the borrower's prime residence is never acceptable as security. This means that in the event of default by the borrower, enforcement of the security, usually sale by an appointed receiver, becomes relatively easy, legally and ethically. Legally easy as there is no need for lengthy court proceedings to obtain vacant possession before a sale, and ethically easy as there will be no need to evict a property occupants from their home. As the security investment properties are occupied by paying tenants under a lease or a tenancy agreement, the property will be sold subject to the lease or tenancy agreement, and so the buyer of the property will still be receiving the rental income generated by the property as his investment. The same principle is applied to commercial properties, as the lender will avoid accepting as security such properties which are occupied by the borrower. In the event of default by the borrower, the usual method of enforcement of the security is the exercise of the power of sale granted to the lender by the legal charge deed, which is registered against the title of the property at the land registry from the outset. The legal charge also grants power to the lender to appoint the receiver. Legally, the receiver is the agent of the property owner, and he will have all the powers by stepping into the owner's shoes, such as power of sale, repair insurance, to commence litigation, grant, vary or surrender leases or tenancy agreements. The appointment of the receiver is the common method which is followed by the lender company. Following the appointment of the receiver will take control of the property by insuring the property and taking the rental income pending the sale. The sale can either be effected by auction or privately, and the receiver must take care to obtain the best possible price in the circumstances. As there is no need for the receiver to obtain vacant possession of the property before sale, in normal case, the sale procedure is expected to take 3 to 6 months from the appointment of the receiver. This timeframe compares favorably with the time required to sell a security property in other non-UK jurisdictions, which in some cases may take a few years.